My name's Dominic Mackenzie, I'm the Head of Wills and Probate at Harrison Solicitors. A lasting power of attorney is a document whereby you can appoint your chosen attorneys to act on your behalf, particularly if you were incapable of dealing with your own affairs and property or making health and welfare decisions yourself. When you set up a property and financial affairs lasting power of attorney, it's open to you to put various restrictions and conditions upon your attorneys. To be honest with you, our advice would be, generally speaking, if you trust your attorneys, think very long and hard before fettering their ability to deal with the assets on your behalf. You can cause serious problems if you limit the authority of your attorneys and subsequently it's found that they need to deal with something but you've prevented them from being able to do so by putting a condition or a restriction in the lasting power of attorney. Anybody can make their own LPA. Our strongest advice, as you might expect, would be that you do obtain professional advice. These are important documents and there are many pitfalls and problems that can arise with people who do DIY LPAs. The LPA can be registered at the Office of the Public Guardian by either the donor, that's you if you're the person making the power of attorney, or by the attorneys. Typically and nowadays we would generally advise registering the lasting power of attorney at the point of setting it up. However, if you decide not to register the lasting power of attorney at first instance, it can again be registered by either you, the donor, or by the attorneys at any time in the future. There are two types of lasting powers of attorney, one relating to your property and financial affairs and one relating to your personal health and welfare. My view is that everybody, certainly those people who own houses and have money in banks, building sites and so on and so forth, anyone who's getting a bit older, they should certainly do the property and affairs version. I've been cynical over the years over how important the health and welfare version is. However, what I will say is that due to various factors, these are becoming more prevalent and perhaps it is the case where more and more people do need to consider and should consider doing a health and welfare power of attorney. Mental capacity means that you understand what you're doing, and if you don't understand what you're doing, then any document created or purported to be created whilst you didn't have capacity wouldn't be valid. We as solicitors tend to make judgment calls on mental capacity in the ordinary course of events many times during the course of our working lives. If we see people to make a will, we will make a judgment call as to whether or not they have capacity. There are, however, various different tests of capacity and there are different levels of capacity that people need to deal with for different things. For example, if you're going to make a will, you need a very, very high level of capacity. If you're going to make a gift, then you need a high level of capacity. However, ultimately, in cases where there's likely to be any doubt whatsoever, at first instance it would become a medical question and a medical practitioner may be employed to give a judgment as to whether or not somebody does or does not have capacity, and ultimately if there is a dispute as to capacity, then it's up to the court to decide. It's up to you in terms of when the lasting power of attorney comes into effect. Our advice would be that most lasting powers of attorney should be registered at the Office of the Public Guardian at inception. However, you yourself can put into a property and financial affairs lasting power of attorney when you want your attorneys to be able to make decisions. Our advice would be that you say that the attorneys can make decisions as soon as the lasting power of attorney has been registered, even though you may at that stage have mental capacity. My point on this is that you may just be old, you may be just frail and infirm, and you may want your children to be able to deal with things for you. And if you've said in the power of attorney that they can only make decisions when you become mentally incapable, you've precluded them from being able to make decisions and deal with things for you when you might be perfectly mentally fine, but due to physical issues of old age such as deafness, blindness, or the fact that you're arthritic, you may cause problems in terms of limiting it to only when you don't have mental capacity. In terms of the health and welfare power of attorney, you can register it straight away, but the attorneys can only make decisions under a health and welfare lasting power of attorney when you are incapable of making those decisions yourself. A lasting power of attorney can be cancelled at any time by you, the donor, as long as you have mental capacity to do so. One of the worst situations that can befall any person and any family is typically an aged relative losing capacity and there being no power of attorney in place to deal with things. In those circumstances, it's necessary for someone, and there's no saying who that someone might be, to apply to the Court of Protection to be appointed what's called deputy to deal with the person's property and financial affairs and other related matters. If you have a spouse and able-bodied and able-minded children who are adults, then I personally would always look towards appointing a mixture of your spouse and children at first instance. If you don't have a spouse or you don't have children, then you should look towards appointing appropriate adult relatives at first instance. If there's nobody who you trust or there's just nobody who you consider appropriate to be your attorney, then you can appoint a solicitor or another professional to be your attorney. However, my view is that this should be the last resort. The responsibilities of attorneys under lasting powers of attorney are set out by the Mental Capacity Act 2005. As you might expect, the basic premise is that the attorneys have to act in the best interests of the donor. That's not the attorney's best interests, that's the donor's best interests. And it's the duty of the attorneys to ascertain what the donor would have done if they'd have had capacity to make decisions themselves. Obviously, the donor is paramount to all of the decisions that the attorneys make whilst acting under the power of attorney. If you'd like any further information, then please do not hesitate to call us on 0113 284 5000.